Hi there, my name is attorney Scott Simmons with the Rossen Law Firm, and I'm here to talk to you about the DUI Trial Experience. So the topics we're going to be discussing today are the theme of your trial, what is and how to properly use motions in limine, jury selection or voir dire, cross-examination or the state's case in chief, judgments of acquittal, the defense's case in chief, and more importantly, your client testifying, and lastly, everyone's favorite, closing arguments. Let's get started with theme. So what is a theme? When you're thinking about what your theme is for a trial, it is the message you want to relay to a jury. So your theme is how you're going to get to not guilty. It allows the jury to easily understand what you're saying. You're saying your client is not guilty. So the most important thing to discuss when coming up with your theme is jury instruction 3.7, which is reasonable doubt. That's how we get to not guilty, is by arguing that there's reasonable doubt in the case. There's lots of different tricks for themes. So there's the rule of threes, that you do 3 different words. There's alliteration where each word starts with the same thing, or there's one that's rhymes. My favorite DUI theme that I had was no drive, no DUI. I was fighting the first element of DUI, actual physical control, and the car was immovable. So the theme was no drive, no DUI. Again, something very simple, only a few words that resonates with the jury, and that when they go back into that jury deliberation room, they're able to think to themselves, he said no drive, no DUI. That's the first element. That means not guilty. We have to check not guilty. That's the whole purpose of a theme. Some things you want to avoid when doing a theme are big, complicated words that you can't say or that the jury won't be able to say. Long sentences, you want to keep them short and to the point. Not every case is going to have the perfect theme. It's okay to just get up there and have your theme be, my client is not guilty of driving under the influence. My client is not guilty. It doesn't always, not every fact pattern is going to fit a perfect theme like no drive, no DUI, but if you can find one, you want to use it. And the most important thing about a theme is using it. So you want to use it repeatedly throughout trial. You want to say it multiple times in your opening. You want to bring it up in cross-examination. If you are putting on evidence, you want it to be part of your evidence, and you want to hammer it home in closing. So the next thing about themes is not only are you going to have a theme, but most likely the state is also going to have a theme, and you have a decision to make. Do you want to try to flip the state's theme? And this is where I have to recommend that you don't do something you're not comfortable with. So if it's not you, it's not going to come off well. But the thing you should know is that most misdemeanor DUIs are going to be handled by state attorneys who are using boilerplate themes, meaning that they're themes that you're going to hear again and again. The 2 easiest ones in every misdemeanor trial is that this is a simple case, or that this is a case about choices. These are themes that you can easily flip by saying that this case is anything but simple. Let's look at all the exercises my client had to do before being placed under arrest. Or if we're going to talk about choices, let's talk about the wrong choices the officer made. Those are easy ways in which you can flip the state's theme. You don't have to flip them. Do it if you're comfortable with it. But again, it's a way for the jury to resonate with your argument. Let's talk about motions in limine. The quote here is, the best defense is a good offense, and that's what motions in limine are. So a motion in limine stands for a motion at the start. What you're doing in a motion in limine is you're asking for an evidentiary ruling on a certain issue before the trial starts. It's important to know what it is not, though. It's not a motion to suppress. You need to make sure that these are filed separately and before trial. Additionally, you don't want to have too much complicated things in your motion in limine that should have been in a motion to suppress, because a judge most likely won't even hear it, or will delay the trial and have it set for just that motion to suppress and move it on. So you need to be very specific in your motions in limine that it's not really a motion to suppress, but just a simple evidentiary ruling. And the purpose of it is for a few things. The main purpose is to allow for a smoother trial. But what you should be using it for is to keep all the bad stuff out and to get all the good stuff in. And most people are used to keeping the bad stuff out, but they don't really understand what keeping the good stuff in means. So you can ask for motions in limine that rule in your favor to allow you to talk about things, or allow the state not to talk about things that is going to benefit your case. So let's talk about the do's when you're writing motions in limine. You want to be as specific as possible about what you want to keep out. If you write a boilerplate motion in limine, judges are going to say, well, this is just the law. I don't need to tell them to follow the law. And they're not going to give you a clear ruling. You don't want that. The whole point is you want to get a pre-trial ruling. The only way you're going to force a judge to do that is if you give them these specifics. So how do we do that? If you took a deposition and you know what you want to keep out, quote it in the deposition. Let the judge know, I'm expecting this testimony to come out that came out in deposition, and I want a pre-trial ruling that they are not allowed to say this, and I want the state to instruct their witness as so. And you want to use the case law and the rules of evidence. You have to back up your argument with case law and the rules of evidence, or you're not going to get the rulings that you want. Let's talk about the don'ts. So, as I said, don't file a boilerplate motion in limine. Especially for DUIs, there are a few standard rules that everyone has, which it's okay to have the standard rules, but add to them. Don't just have the generic rule of law. Apply facts of your case to it. And don't just state a rule of evidence. Don't just say, I don't want to allow in any hearsay, because if you say that, the judge isn't going to rule on it. I don't want to allow in this specific hearsay that I believe this officer is going to try to allude to, and then state what it is. That will get you the ruling you want. And the other thing is, try not to file them at 2 a.m. the night before. It's difficult for some people. You don't know which cases are, especially public defenders, you might not know which case was going to trial until the day before. But judges look at when they're filed, and some judges will get upset that you filed your motion to eliminate at 2 or 3 a.m. the night before a trial. Even if they get upset with you, though, your goal and your job is to make sure that they listen to your motion to eliminate and that they rule on it. So let's talk about the main topics in a DUI motion in limine. So as I said, hearsay and confrontation clause. Statements through dispatched or unlisted witnesses. These are going to go under hearsay and confrontation clause. And just for anyone who doesn't know, they are separate and apart, and you need to make an argument for each one, because not everything that is hearsay is a confrontation clause violation. Uncharged crimes. Either it's pills that weren't tested or pills that for some reason weren't charged. Your client may be mentioning something else that happened before the DUI that wasn't charged. A lot of DUIs have around them uncharged crimes, and you want to make sure that any mention of them is not allowed in the trial, and that if it's on body-worn camera, that body-worn camera is redacted. If you're trying to get information redacted, your motion to eliminate should not be heard the day of trial. The state's not going to be able to redact that footage in time. That is a motion to eliminate you're going to want to have heard earlier. The case I cite for the next 2 points, it's a really important DUI case. I recommend everyone read. State v. Meador, 674 Southern 2nd, 826. It's a Florida 4th District Court of Appeals case. So the first thing it stands for is that field sobriety exercises are just that. They're exercises. So officers can't use the word test. They can't use the words pass or fail. Again, that's really important because it allows the state not to strengthen the argument that field sobriety exercises are tests and that your client failed them. You don't want that kind of testimony coming out. It's going to hurt your case. You want the fact that these are exercises. Make them lose credibility with the jury. The next is that officers can't testify about the horizontal gaze nystagmus, the HGN, unless they're DRE or a drug recognition expert certified. Most officers aren't going to be DRE'd, so they're not going to be allowed to talk about the HGN. They'll be allowed to talk about the pen test and talking about how someone's followed the directions, but not about the specific eye movement. So they'll be able to say, well, I gave him the instruction to keep his head still, and he didn't follow that, or he was swaying while doing the pen test, but they won't be able to talk about the smooth pursuit or the distinct and nystagmus. You don't want the scientific evidence coming in if they're not DRE certified, because then you don't have to fight it. And if you don't have to fight that evidence, it's better for you. Another great case to have is Martinez versus State. That is, a witness's opinion as to the guilt or innocence of the accused is not admissible. Again, you don't want officers testifying that they thought your client was guilty. A lot of judges don't like to just grant this one. They consider it more of a boilerplate one, but you want to try to get the arguments that are good for you in your motions in limine, which is that you don't want officers being allowed to say that they thought your client was guilty. And again, back to redactions. You want to make sure that you reviewed your body-worn camera and that you try to make an agreement with the prosecutor beforehand on which parts you want redacted out. If you try to do this the day of trial, it's not going to go well. So you want to do this about a week or 2 weeks before the trial, so that way you get out what you want out and the jury doesn't accidentally see it. Just because you and the prosecutor agree that you're only going to play minute 1 to minute 2, but if you enter the entire disc in, they can go and watch whatever's left. They can go and press play in the jury room. And they can see the 2 to 5 minutes that you didn't play for the jury. So you want that video redacted. Let's talk about some practice tips for motions in limine. I always recommend bringing at least 3 copies, one for you, one for the judge, one for the state. If you have a trial partner, you want to bring one for your trial partner so that they can mark along as to how each number was granted or denied. You want to try to ask the state which ones they agree to beforehand. Even if you're asking when the jury's on their way up, try to get some concessions early on. Judges will appreciate that. You want to make sure you get the judge to rule on every single issue, and then you want to get that order in writing. So that's why I was saying your partner should have a copy of the motion in limine, and they can be writing number 1 granted, number 2 granted in part, number 3, and then you take that order, you write it on a little short order, give it to the clerk, get the judge to sign it before you guys start voir dire. That way you have the pretrial rulings in the court file in case you need it for an appeal. And the most important thing is, even if your motion in limine is denied, you object during trial, or you're waiving that right for appeal. Especially in the 4th District Court of Appeals, if you don't object contemporaneously, you've waived that objection, even if you objected 10,000 times beforehand. If you didn't object in that last time, you're waiving your issue, so you always need to object. You don't need to be rude, just make your objection, judge objection, same argument as my motion in limine. They deny it again, they deny it again. But again, it happening in the trial, the judge now has more facts than they had when you were making your motion in limine. Maybe they'll even grant it this time. Let's switch over now to voir dire, or jury selection. So, jury selection or jury deselection. This is the most important part of a jury trial. That's why we call it a jury trial, because it's the jury. As I tell every single one of my clients, I go, if I could handpick every single member on your jury, I don't care what you're accused of, you could get a not guilty. Because if I got to pick all of your best friends, they're going to find you not guilty. Same for the state. If the state could handpick every single person on your trial, it'd be a guilty no matter what the evidence is against you. That's why the jury selection process is so important. But the main goal is going to be to find out who is biased, get them to admit their biases on the record, and then get them stricken for cause. That's the main goal of jury deselection, is to figure out who you do not want on your jury, find a reason that they are not allowed to be on that jury, and then they're done. The second goal is to get the jury to like you and your client. This is your first and main opportunity to actually have conversations with the jury, and you have to use it as such. You have to show off a little bit of your personality, not just be a robot with a script, and get them to like you. Because most likely the state's going to be a robot with a script, and they're not going to like them. They're not going to think they're human, where you are going to be humanizing yourself and your client, and they're going to want to agree with you over them. And the secondary goal is to pre-try your case. Get ideas and concepts into the jury's mind before they hear any evidence, so that when they do hear that evidence, they're viewing it in a light most favorable to you. And remember that practice makes perfect. You can practice your voir dire on your friends and your family. They're going to forgive you. Before I ever did my first voir dire in a courtroom, I practiced it on all my friends. They all got annoyed. But you're just getting people to speak. That's the purpose of voir dire. You're asking general questions. You're waiting for one juror to give you an answer. You're responding, and then you're asking other jurors, do they agree or disagree? And you're just trying to cause a conversation, and you're basically the mediator or the panelist of a conversation with the jury selection panel. So we talked about that we want to figure out about someone's bias. So how do we figure out about their bias? You have to ask them questions. You have to just get them talking and engaged in what you're saying. So one thing that I see that happens a lot with people doing their first voir dire is that they've run through their own script and they just keep talking and they just ask, do you agree or do you disagree? And they're doing all the talking. If you're doing all the talking, you're not doing a proper voir dire. The jurors should be doing the talking. The more time you're talking, the less time they're talking. That means the more time you're talking, the less they're talking, and you're not learning about them. You have to find the balance of causing the conversation and then stepping back, letting them speak, and then switching which jurors you want to hear from. So that way you're getting to hear from everybody, and you're figuring out who has biases and maybe even who you like. So let's talk about DUI voir dires in specific. So one question that everyone loves to ask in a DUI voir dire is drinking and driving legal? Because the answer is yes. And that's not what we're here to discuss today. This is driving under the influence. That allows you then to talk to jurors about who here is a social drinker. If someone raises their hand and says there's a social drinker, what does that mean? What does social drinking mean to you? Okay. Do you go to dinner and have a glass of wine? Yes. Why? Well, because it's not illegal. Exactly. Why is it not illegal? Because I'm not impaired. And then you talk about that. You can continue going, Well, how do you know you're not impaired? Is it just one glass? Is it two glass? Do you know what number of glass equals you're impaired? And then you can talk about how do we determine if someone's impaired? And you want to be careful with this because, again, you don't want facts from your case that the officer is going to say that your client was impaired coming out, and then you're kind of pre-trying your own case against you. So this is an area where maybe you want to say, are these signs of impairments that you would look for, knowing that there were signs of impairments that your client didn't have? So if your client didn't have slurred speech, you can say, show of hands here, who knows that slurred speech is a sign of impairment? Okay, is that a big sign of impairment or a small sign of impairment? And you can go based off the ones that you know the officers aren't going to testify about. Another important question to ask anyone is if they were negatively affected by a DUI. This will usually come out during the judges. Judges usually have like a 10 to 15 question voir dire that they do before the state. You'll usually get these answers from the judge or the state attorney's voir dire. But if you don't, you have to know who's been negatively affected by a DUI. Whether they were a victim of a DUI, they've lost a family member or a loved one to a DUI, or they've even had a DUI. These are typically people you're not going to want on your DUI jury panels. Other people you're not going to want typically are people that don't drink. It depends on what your trial strategy is going to be, but you want to know who's a drinker and who's a social drinker. You want to know these answers so that way you can decide who's the best juror for your panel. Now, a big thing we need to discuss is there's two main types of DUI cases. There's breaths and there's breath refusals. Your case is going to be one or the other, and you really should address it in voir dire or you're doing yourself and your client a disservice. So let's go into refusal first. So I always like to let the jury tell me why my client refused. And the way I do this is I ask a question. There's a very important word that you put in the question. What are some reasons why an innocent person would refuse to take an intoxilizer test? And the reason you have to ask it that way is because I had a trial partner who missed the innocent word, and he asked, what are some reasons a person would refuse a breathalyzer? And the first answer we got was, he's drunk. Everybody laughed, and that's what they're thinking of now. Again, you want to put perceptions in the juror's mind while also figuring out who is a creative thinker that would be good for your panel. So you want the people who are going to say, well, maybe they don't trust the machine, or they were already under arrest, or they didn't understand what they were being asked, things like that. Those are the answers you're looking for. And if you don't get them, that's fine. Wait, see if anyone has one, call on some people, and then you can give them out. And again, the repeated comments that you're usually going to get are that people don't trust machines, or they know breathalyzers don't work. You want them to know that your client was already under arrest, or that maybe they were even annoyed with the officer and they just didn't want to, they trusted the officer and the officer arrested them, so they didn't want to help the officer anymore. Those are all plausible reasons why someone who is innocent would refuse the intoxilizer. And now when it comes to DUI breath, these are cases that people normally don't try as much as refusals, but they're still triable. And as Adam was speaking about, you have to attack the intoxilizer and you also attack it in voir dire. So ask anyone, do they know how it works? Does anyone know the science behind an intoxilizer? No? Okay. Then you ask people, do they trust all forms of science / the evolution of science? So can someone share an example of a time when science was wrong? And nowadays, there's going to be a lot of people who are going to have a lot to say on that topic, which is controversial, and it's okay to bring up controversial topics like that for this. I really like two different analogies, which my first one, I call it the doctor analogy. Second one's the metal detector analogy. So for the doctor analogy, it's that you feel perfectly fine, but you decide you go to a back expert, and this is the best back surgeon in Florida, and he runs a test on you. You don't really understand what he did, but he told you need to get surgery immediately, that you have to get surgery, but you feel fine. Show of hands here, who's going to get that surgery? Most people won't raise their hands. Then you call on someone, why wouldn't you get that surgery? Would you want a second opinion first? Yeah, why? Because I feel fine, I don't know. So even though that's an expert, you don't just automatically trust them. No, I definitely want a second opinion. It's a great way to bring up the fact that just because a scientist or someone that we deem an expert is saying that we have to do something, doesn't always mean we do. The metal detector analogy is that every single person who was in that courtroom went through a metal detector. Show of hands here, who had the metal detector go off on them, but they had no metal on their body? You're going to get some show of hands. So what does that mean? Was the metal detector right or wrong? Well, it had to be wrong. I didn't have metal on me. Okay, so we had a machine whose job it was to detect if you had metal on it, and it was wrong. Yeah? would you trust your liberty? Would you trust that this metal detector was right all the time then? No. And that, again, it's another implementing that these intoxilizers, it's infallible science. It doesn't really work, and they don't know how it works. And because they don't know how it works, it's the government's job to prove to them that the science works and that your client's breath is something that they should consider. If you are trying a breath case correctly, the jury should not care what the breath is. They should not believe that the breath was accurate or that it means anything about your client's breath at the time of driving. And Adam spoke about that a lot more. And you don't want to forget your basic topics whenever you're doing a voir dire. No matter what the charge is, you want to talk about the presumption of innocence, the burden of proof, reasonable doubt, whether or not your client is testifying and how they view that, and credibility of all witnesses. These are some basic cases that I think everyone should have in their trial binder as far as voir dire goes. So you have the right to voir dire on your defense. There's the case. Hypotheticals are okay. So there's lots of judges who, for some reason, they don't like hypotheticals. If you come across a judge who doesn't, you can give them a copy of this case. And I think the most important one to have in your binder is that rehabilitation doesn't work. A juror's subsequent statement that he or she could be fair should not necessarily control the decision to excuse a juror for cause when the juror has expressed genuine reservations about his or her preconceived opinions or attitudes. Again, it's whether or not you have a reasonable belief this jury could be fair and impartial. That's what you're looking for when you're trying to strike for cause. And it's really important that if you believe you have a cause challenge, that you fight and you fight and you fight to not have to use your preemptory challenge. Let's switch over to opening statements. So what is the purpose of opening statement? You're telling the jury what to look for, what not to look for, and what they're going to see, and most likely in a DUI trial, what they're not going to see or hear. I love opening statements. I think they're very important, and I recommend that you don't just wing it. I always write out a couple bullet points for my opening statement. And the reason why is this statistic I put on here. As many as 80% of jurors make up their mind immediately after hearing opening statements. So I heard this and it resonated with me a lot, which is, let's say this 80% is wrong. Let's lower it to 70. Let's lower it to 60. Let's lower it to 50. 50%. Half of your jurors have their minds made up by opening statements. That means you have a hung jury if you want openings. That's crucial. So if you pick the right jury and you had a great opening statement, you're now at a hung jury. That is very crucial for your case. So that's why you shouldn't just wing it. A lot of people think, oh, it's opening statement. I'm just saying what the evidence is going to show. It's not important. It truly is an important part of the trial, and you don't want to waste your first opportunity to be convincing to the jury about your defense. So let's talk about a couple tips for opening. So again, we're going to talk about theme. You want to start off with your theme and incorporate it throughout the entire trial. And even if it's saying that your client's not guilty, it should be the first thing out of your mouth. Make it something memorable. You also want to humanize your client. And the way you humanize your client, you don't call him your client, you don't call him the defendant. Depending on the theme or how you are treating your client, you might want to call them by their first name if the judge allows you to and it works with your client. Again, if you have a younger client, you might want to call him Johnny, so that way he looks like a younger kid, but you don't want to be calling the older 80-year-old man by his first name. Usually you want to be calling him Mr. whatever, Mr. Smith, so that way he looks like an elder that we should be respecting. You always need to emphasize the burden. We don't have a burden of proof. The government has the burden of proof to prove their case beyond and to the exclusion of every reasonable doubt. I always love to tell them how they're going to find not guilty. So they're going to find it through the lack of evidence, the conflict in the evidence, and the evidence itself. Again, that comes from the jury instructions. So you want to pick in your trial, where is the lack of evidence? Where is the conflict in the evidence? And what evidence do you have that supports that your client's not guilty? So the evidence you may have is also the lack of evidence. They intertwine with each other. It's okay. You don't have to use all three. If you only have one or two, use them though. Bring them out in opening. You'll see the jurors. They're going to write this stuff down, and that's what they're going to be looking for throughout the trial. In DUIs, I love to pose questions to the state that I know they're not going to be able to answer because jurors like this. Again, I'll pose 3 questions that the state can't answer. When did my client drink? What did he drink? How much did he drink? They can't answer these 3 simple questions, and because you're going to have more questions than answers throughout this trial, you're going to have reasonable doubt. But the most important thing is to be yourself. If you're not If you're not a super energetic person, don't do that for your opening. It's not going to come off as genuine. You have to be yourself so that way you can convey your theme and your theory and the purpose that your client is not guilty. The only way you do that effectively is by being yourself and not being somebody else. So let's talk about a couple do nots for opening. So I always say do not oversell, but luckily we're the defense, so we're allowed to pound the table. It's much harder for you to oversell in an opening, but the state's going to oversell. And if it comes down to who they like and who they think they're telling the truth, they're going to believe you over the state if the state's overselling. So just make sure you're being believable. Again, if your client admitted to drinking, don't get up there and say, my client didn't have a single drink that day. There's no need. That's not your burden. Don't shift your burden to my client didn't drink when it's your client's not driving under the influence. That's why you don't need to oversell. And you don't want to take away from your opening. So a lot of people love to say, what I say is not evidence. What I say is not evidence means what I say is not important. That's fine. The state's going to say that what you say isn't evidence. They can make that argument all they want. You want them paying attention to every single word you're saying, because if you're not, you're saying it because it's important. So don't take away. If they're going to object to you being argumentative, then you can say the evidence will show. But I don't like using the evidence will show unless I'm getting objected to, because it takes away from your opening. Just tell your story the way you want to. Be persuasive. In order to be persuasive, you can't be reading. So that's why I always like to write out bullet points and not full sentences when I'm doing my opening statements or my closings for a matter, because then you're not going to read. If you only have a couple words and not full sentences, you're less likely to read. Also, don't worry about being objected to. A lot of people are so concerned they're going to get objected to in opening that they take stuff out. It's okay to be objected to. All that happens when the state objects, the judge is going to sustain or overrule it. If they sustain it, you repeat exactly what you said and you say, sorry about that. The evidence is going to show, and then repeat exactly what you said. And they just highlighted what your argument was. And all you did was say the evidence is going to show, or the evidence is not going to show. So don't worry about being objected to. Don't get flustered. Don't go and make a face to the prosecutor or the judge. Just deal with it and continue with your argument. All right, let's switch gears now to the state's case in chief, cross-examinations. So, cross-examination basics. Let's talk about what is the goal of cross-examination. And the goal of cross-examination is the goal throughout your entire trial. You want to lead to reasonable doubt. Let's talk about the basics, which is you're going to ask leading questions, which means your question is eliciting a response. You're going to only want to put one fact per question in. And you want to take your time. You want to be methodical with your cross-examination. Death by 1,000 swords. Let your good points sink in. So if you make a great point, stop, look at the jury, then go back to your cross-examination. That way they can understand. If you just hit them with a lot of zingers really quick, it might not be as impactful to the jury. And one thing you don't want to do, especially for your first couple cross-examinations, you don't want to ask questions you don't know the answer to. So if you didn't have the opportunity to take depositions, or if it's not in the report, or they didn't say it in direct, you might want to be careful asking the question because you might get an answer that you don't know how to deal with, and then you put yourself in a pickle. And always be prepared to impeach. So if you know that you have a contested area, have your body-worn camera minutes lined up, have your depo transcript ready. Your trial partner should be ready to hand it or press play for you so that way you can have a smooth impeachment. So how do you prepare for your cross-examination? You have to review everything. And in reviewing everything, make sure you have everything. Go through the state's discovery exhibit, put a check mark next to what you have. If you don't have it, you better send an email and get it really quickly. You want to have probable cause affidavits. You want to make sure you have all the supplemental reports. If you did the DMV formal review, which a lot of, again, public defenders, you're not going to have those transcripts. But if you did, make sure you have those transcribes. Make sure you ordered your deposition transcripts, that you have them. Make sure that you have all of your videos and that they're working. So the body-worn camera, the in-card video, the dash, BAT facility is sometimes missing. Make sure you have all of it, that you reviewed all of it, and you have the important parts lined up. So that way, if you need to impeach or use it, you have it. And make sure you have the toxicology report if it's a breath case. Next, you want to write out your cross-examination. This is going to be for the arresting officer. So when I do my arresting officer cross-examination, I write it out like a book in separate chapters. And these are the chapters I go through and the ones we're going to go through really quickly. Chapter 1 is going to be the intro, the background, the building the officer up. Chapter 2 is going to be about the stop or how the officer got involved with my client. Number 3 is going to be from that initial interview to when he started hunting for a DUI. Then we have the DUI investigation, the field sobriety exercises, arrest, and post-arrest. And again, not every chapter is the same size. Your biggest chapters are going to be chapter 4 and 5, the DUI investigation and the FSEs. So as we discussed, the goal of crossing an arresting officer, same goal as any other cross-examination, same goal as the entire trial, to get to reasonable doubt. What are we focusing on, though, for the arresting officer? Lack of evidence of impairment, the things the officer did wrong, and the things that your client did right. The things the officer could have easily done or asked and did not. So again, that goes to things the officer did wrong, that the officer did an improper and inadequate and incomplete investigation. Those are things you want to highlight, as well as the things your client did right. So did your client get out of the car without stumbling? Did he do really well on a certain field sobriety exercises? These are things you're going to want to highlight. At the end of every cross-examination, the jury should believe that you are the DUI expert, not the officer, and understand that the DUI investigation better, that they should believe that you understand DUI investigations better than the officers. That's an effective cross-examination of a DUI officer, is you take away their credibility and now you're the credible DUI expert. Chapter 1 is the intro and background. So the main points to highlight are if an officer has lack of training or experience and that they did an improper investigation. Lock them in that it's their job to collect evidence. Always lock them into this and lock them into the fact that all relevant facts are in the reports. So I do both of these for 2 different reasons. So the lock them in to collect evidence, there's usually going to be some piece of evidence not collected. Did they see an open container in your client's car and that's not getting admitted into trial? Was there a statement of an independent witness that they didn't take? There's always going to be a piece of evidence that they didn't collect, and you want to exploit them because the jury watches Law and Order SVU. They expect that they're going to have every single piece of evidence, and especially in these misdemeanor DUI, they're not going to have it. The next is to lock them in that all relevant facts are in their report. I asked this very early on before I start hitting them with facts because then they can't go and say, oh, well, yeah, that isn't in my report, but I definitely saw that. Officer, I asked you at the beginning, were all relevant facts in your report? And you said yes. So you're changing that answer now. Yeah, so after you reviewed your report, after you testified on direct examination, this is the first time you're adding that to your testimony. And they're going to really lose their credibility if they try that. So the chapters 2 and 3 kind of go together, the pre-DUI investigation. Again, you're going to focus on the lack of investigation. It might have only been a minute or two from when they stopped your client to when they started their DUI investigation. You want to emphasize how short of a time that is, that they only took a minute and a half to realize whether or not they knew your client. That's not enough time to get to know someone. So the officer is going to point on the signs of impairment that he saw, and your job is to attack those signs of impairment, how there's innocent reasons those signs are not attributed to signs of impairment. So examples are that red eyes. Well, red eyes can be caused by allergies. Is that correct, officer? Yeah. Did you ask him if he had allergies? No. Did you ask him if he was on allergy medication? No. Is it allergy season? No. You didn't ask any of these questions? No. Could you have asked those questions? Yes, I could have, but you chose not to, right? That wasn't worth your time. Then we're going to go into the DUI investigation. You're going to focus on the fact that the officer is making assumptions and doesn't know your client. So again, sees, hears, talks, judges, and says drive a car. Why do I have those examples? Those are the exact thing that the jury instructions define as normal faculties. This officer doesn't know your client. As we just said, they probably met your client for 3 or 4 minutes. They don't know how they see. They don't know what their hearing is. They don't know if they have an accent, if they're from this country. They don't know any of that. They don't know if they judge distance, and they never saw them driving except for this one instance. Again, if we have a 19-year-old and a NASCAR driver, we expect 2 different types of driving patterns. So without knowing who your client is, how can they say how they normally do these things? They can't. They're making assumptions. The next, chapter 5, is the field sobriety exercises. This is the most, if your client did field sobriety exercises, this is going to be one of the most important parts of your cross-examination. And you need to write out every question by question, line by line, go through the entire body-worn camera video if there is one, and be ready. I love using NHTSA, the National Highway Traffic Safety Administration guidelines, for writing out my FSE cross-examination. And these are the two websites where you can get those documents. It's going to show you how officers are trained to conduct DUI investigations in the field sobriety exercises. So what instructions are they required to give, and then what clues are they required to look for? Because that's all that matters. And if they deviate from either of those, the exercises are invalid. They're not reliable. So you're going to focus on, did they give the right instructions according to NHTSA? So if they didn't, you want to get them to say, if they fail to give the right instructions, it affects the reliability of the exercises. They have to. They have to say that. Same with looking for the right clues. If they weren't looking for the right clues, the exercises are less reliable. They should concede to that. If not, it doesn't sound reasonable and you argue it to the jury in closing. You also want to emphasize how the goal is so high for field sobriety exercises. So for the walk and turn, it has 16 separate instructions, and if you only do 4 of them wrong, you have an unsatisfactory performance. So again, if your client did 12 out of 16 exercises correctly, but they still were considered unsatisfactory or they were still arrested, that's not reasonable. Again, he walked on the line. He didn't stumble. He counted out loud correctly. He didn't use his hands. He did all of these things correctly, but he was still arrested. We saw how he performed. His normal faculties weren't impaired. I always love focusing on the fact that your client was given one chance to do these. The opportunity to do so was under nervous conditions. Maybe there were cars coming by, lights and sirens going off. Obviously, he's panicked because an officer is asking him to do these things, and he was distracted by other things going on. You want to point to all signs of innocence as to why the few things your client did poorly, why those aren't signs of impairment, and why they're signs of someone just being a normal person. Chapter 6 and 7 are the post-arrest. This is going to be for refusal cases. You need to highlight the fact that they were only asked to give a breath sample after being arrested. So the officer made a determination that your client was guilty of DUI and then asked for breath sample. So how does that make sense to a normal jury? Now, we all know that that's just a protocol they follow, but that's something you could argue in closing is they had all the evidence they needed. That's why they arrested him. Why would they arrest him and then ask for more evidence? You also need to remind the jury that even if he blew a 0.000 that day, there's no being unarrested. If he blew a 0, they were going to ask for urine. If they blew a 0, he was spending that night in jail regardless. Those are both really important facts that have to come out in refusal cases. Then let's talk about breath cases. So there's multiple ways to attack breath, and you want to use them all. Adam went through them in plethora. I'm going to just hit a couple of them really quickly. So typically the breath samples are going to be taken about an hour later than driving, sometimes 2, sometimes 3. That's not the burden the state has to prove. The state needs to prove their breath level at the time of driving, not an hour later. And every breath tech will testify that they can't testify to what their breath was at the time of driving based off a breath test an hour later. So it's not even important. And the reason why they can't testify to what it is the 2 breath samples that they get, it can't tell you whether or not someone's eliminating alcohol or absorbing alcohol. So it can't tell whether their numbers are going up or down. There's a formula that they can use to do this. No one that you do a cross-examination on a normal DUI will know how to do this formula. And even if they did, they can't do it with 2 breath samples. They'll need more breath samples to do it. Typically, the breath tech is never going to even know how the machine works. Their job is to just turn it on, tell your client to blow, 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 blow until it beeps, sit them down, wait 20 minutes, do it again. That's their job. They don't know the science behind it, and you want to attack the fact that they don't know the science behind it. Because if they don't know the science behind it, why do we trust the science? You also want to attack that blood is more accurate. So in DUI manslaughter cases, they take blood samples only, not breath, and they take 2 different blood samples a long time apart from each other, so that way they can do that formula to determine what their blood sample was, their blood alcohol content was at the time of driving. That wasn't done in this case. And again, we don't have a burden, it's the state's burden. Why didn't they use the more accurate science? So you're going to attack the machine as much as you can, you're going to attack the science as much as you can. Let's switch over now to the judgment of acquittal. So Rule 3.380 is a motion for judgment of acquittal. There's 2 different ones. So they have slightly different standards from the first to the second. So the first is viewing the evidence in light most favorable to the non-moving party. The state has failed to prove a prima facie case of driving under the influence because, and then you have to insert your argument. You want to attack each element. You want to attack both elements. Even if you have very little to say, attack it attack it, don't waive your argument. The second JOA is under the higher burden in viewing the evidence in light most favorable to the state. No reasonable jury could find beyond a reasonable doubt that the defendant committed driving under the influence because, and then you're most likely going to repeat the same exact argument. Again, you're attacking every element, actual physical control and impairment. I have gotten a judgment of acquittal on impairment. It's very rare. It was a second judgment of acquittal that happened, but that's why you have to make the argument. If I just sat there and I gave a boilerplate argument, the judge might not have granted it, even if she believed the evidence showed that, because I didn't make the argument well enough. Treat these as arguments and don't waste your opportunity. If you get it granted, it's phenomenal. Make sure that they state proved venue. Make sure they identified the client. These are two very important things that sometimes don't happen in a trial. It's very rare that it hasn't happened, but it does happen, especially in misdemeanor DUI trials. If it's two first-time prosecutors trying a case, maybe his trial partner didn't remind him, he missed the venue, that's an easy JOA, and you just got to win for your client. So let's talk about the next part of trial, which would be the defense's case and whether or not your client's going to take the stand or not. So the most important thing is it's your client's decision, not yours. All you can do is advise them to the decision and let them know your belief and hope they trust your judgment. So the pros of your client testifying is it can lead to reasonable doubt. Jurors get to know your clients better and may like them, and they can explain away signs of impairment. But let's look at the cons. Your client can come off bad, meaning that they now don't like your client. Your client can incriminate themselves, and your client has nothing to add. I love in voir dire to bring up when talking about client testifying, taking a knee in a football game. So you ask someone, why does a team take a knee? And it's because they've already won and they don't want to risk losing. So it's a concept that helps a jury kind of understand why your client chose not to testify, which was there was no need to. He didn't want to risk it. I think it sometimes relates to people more because it's a football analogy that they understand than just citing the Constitution to them. But again, you have to be concerned. If you put your client up there, what your client says may make or break the case. There have been cases where you would have had the not guilty had your client not testified and vice versa. So it's a decision that you and your client have to make in every case. If your client didn't admit to drinking on the scene, but there's an odor of alcohol, you better believe that a decent prosecutor is going to bring that up. And he's better have something to say other than, no, I didn't drink anything. I don't know why I smelled like alcohol. The jury's most likely not going to believe that. So those are questions like that you need to talk to your client about. Hey, these are potential questions you're going to get asked. We're going to have to deal with it. Do you think your answer is going to help or hurt us? Lastly, let's go to a closing argument. So this is everyone's usually favorite part of the trial. It's the showtime. You're bringing it all together. Remember to be confident and make a connection with the jury. So the formula for a closing argument is kind of the same formula for an opening. You're going to go over your theme again, an evidence review, talk about what great evidence came out for you, highlight that burden, highlight that the burden's beyond and to the exclusion of a reasonable doubt. It's not your burden, it's their burden. Why you won, why they lost, and conclude. It's really important. You can repeat yourself in a closing argument, but you don't need to. If you get up there and you give a 5-minute closing argument, that's totally fine. I would hope you give a little bit more, maybe like 10 minutes, but if all you have to say is 5 minutes worth of stuff and then you feel like you're rambling, it's okay. You don't have to use all of your time. Just because a judge gives you 15 minutes doesn't mean you have to use the 15 minutes. It depends on your case. If it's a one-officer case, officer didn't say that much, you might not have a 20-minute closing argument. That's totally fine. So let's talk about the do's and don'ts of closing arguments. So the do's, obviously you want to be persuasive, you want to be prepared, you want to have stuff written out. You have to use your jury instructions. Weighing the evidence is one of the most important ones. You want to use your time correctly. As I was saying, you're going to get a time limitation. Don't get 15 minutes and then not finish what you have to say and be only halfway through your closing when your time's up. You're going to want to rebut the state's arguments. They went up first. If they made a really good point, highlight why their point wasn't that good. And I love to use at least one thing from voir dire. I like to use way more if possible, depending on how good the voir dire is. But remember when juror number 3 said, you can't convict if you didn't have enough evidence. And look what we heard. We heard no evidence in this case. So juror number 3, we know you're not going to be able to find my client guilty. Whatever it is that they gave you, whatever nugget that they gave you in closing argument, make sure you keep that nugget, write it down, have your trial partner write it down, and relay it to the jury again in closing arguments, and you'll see them start nodding along. Oh yeah, I did say that. Yeah, that resonates with me. And then you're able to better connect with them. Let's talk about the don'ts. Don't attack opposing counsel. Don't get personal. I always try to just refer to them as the government throughout my entire trial with them. I like using the word government. People don't like the word government, so I like doing that. I don't like using their names. One thing that I see a lot in first closing arguments is people just yelling conclusions. He wasn't driving under the influence. He's not guilty, and just repeating them, but not explaining how they got there. Well, we know he's not guilty because we know he didn't commit DUI. How do we know he didn't commit DUI? Well, he didn't even have actual physical control of the vehicle. We heard officer testify to blank, blank, and blank. We know his normal faculties weren't impaired. We got to watch the body-worn camera. In the body-worn camera, you heard him talking okay. You saw with your own eyes that he was walking totally fine. He wasn't staggering. He wasn't stumbling. We saw all of this. And maybe you got to see driving pattern. We got to see him operate a motor vehicle. There were no issues. He was pulled over for speeding. Attack with analysis. Remember IRAC. You need the rule and the analysis to get to the conclusion. You know the rules in the jury instructions. You need that analysis. You need to explain how they get to not guilty. And when you're trying to be persuasive, we talked about it in opening. I'm going to talk about it in closing. Don't read. I really recommend going up with bullet points, and I really recommend going up with notes. I think if you go up to a closing argument without any notes in front of you, you're going to forget your important points, and you're going to miss it. It's okay to pause. It's okay to look down, gather yourself, and make your arguments. And again, lastly, don't make baseless arguments. If your client had an odor of alcohol, you don't need to argue that they didn't drink. That's not the burden. Don't put a burden that doesn't exist in your case. And don't make baseless arguments that now the jury doesn't trust you. I want to go over some of the main objections in closing. So disparaging the defense is a really common one, especially in misdemeanor trials. So them calling your defense a distraction, a smoke show, telling them to completely disregard it. These are all things that you can object to disparaging the defense. You really have to look forward to an improper burden shifting happening in any misdemeanor trial, especially a refusal case. They're going to say, well, why didn't he blow? The law allows them to talk about consciousness of guilt, which is he blew because he knew what the test was going to show. That's fine, but they can't talk about, well, we don't know what the breath is because he didn't blow. That's going to be improper burden shifting. Don't let them improper burden shift. If you get an improper burden shifting, you don't want to just object. You might even want to move for a mistrial. That's something you need to talk to with your client before you move for the mistrial. It's part of their decision as well. You want to look for golden rule objections. So is the state asking the juror to put themselves in the position of another party? So what would you have done in that situation? What if you were the car he hit? Those are all improper golden rule arguments. Again, you want to object. You might want to move for a mistrial. Not as blatant and egregious as improper burden shifting, but something you may consider. And an improper argument, message to the community. So we need to stop drunk drivers. If you don't vote guilty, you're going to allow them to do this again. You don't want any kind of comments like that being made. Again, with misdemeanor prosecutors, you don't know what you're going to get. You don't know what arguments they're going to make in closing arguments if you've never seen them try a case before. So you have to watch out for all of these. So that's all I have. I hope you guys really enjoyed this. I hope it helped you. If you have any specific questions, feel free to scan the QR code, email me. I'm happy to share any of my DUI trial prep materials that I have. I have all my trial prep materials from all my DUI trials. So I'm here to help. I hope you guys found this really informative. Thank you guys.